Let's call the case. People versus Jaleesa McDowell.
Allegation on behalf of the people, Your Honor. Asli Bashir on behalf of Jaleesa McDowell.
Jaleesa McDowell.
And Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address bond before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that there's a case out of 14A2, 25203, okay, actually, you know what, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that
Out of my court?
Oh, sorry, 1482.
So what would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far as this matters, yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes.
Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
Screenshots.
Yeah. And we do, we are gathering discovery on the matter. And I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell.
Got her moved.
Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell has there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Yeah, okay.
You're saying the bond I set was excessive?
Well, at present, given the current circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And, she has already been in custody for 15 days. The final matter is, she has, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other two children?
My kids were left at home, attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now, and I did sign my rights over, sir. But my children were left home, attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with a grandmother.
I got to move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just
and I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir, and that is taken care of. And it was you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds, and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I do know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, if the court's familiar with this case, I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is being accused of stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police, she had to have text a friend to call police because she was so afraid. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case, and I believe in our bond form, our original request was $100,000, so $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, there is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And her stitches.
Well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say I don't believe. I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
You're telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered a knock.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
Same teenager.
I did also make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She had a DV conviction. Motion for bond reduction is denied. Bond will continue.
The courtroom focused on 2 defendants asking for lower bond, but the judge refused both requests after reviewing the serious allegations and their criminal histories. In the first case, Jaleesa McDowell's attorney argued that circumstances had changed and asked for her release with GPS monitoring. However, prosecutors pointed to allegations that she seriously injured her teenage daughter with a knife, threatened her, and had previous convictions. The judge ruled that public safety came first and denied the bond reduction. The second case involved Barrage Scott, who had recently been found competent to stand trial. His attorney explained that he was receiving mental health treatment, had strong family support, and was willing to follow any court conditions if released. Mr. Scott personally asked the judge for another chance, admitting he struggled with mental health and drug addiction. Despite his emotional statement, the judge reminded him that he had already been given previous opportunities and was arrested again shortly after being released. The court denied his request, making it clear that trust must be earned through actions, not promises.